Hi, and welcome back. This is Chapter 1, Parts B and C of your commissions, how to obtain it, and how to manage it. In Section B, we will discuss the terms of the office, the geographic locations in which you can notarize documents. We'll discuss your bond and how this works for public employees that are notary publics for the public. In Part C, we'll talk about how to manage your commission, about filing the oath and your bond with the county clerk, any address changes, name changes, and responding to written requests of the California Secretary of State. And we'll discuss agreements between private and public employers. Let's move on. Please remember to record your start time and your ending time on your timesheet provided in your workbook at this time. The term of office for a notary public in the state of California is for 4 years, starting with the commencement date stated in the commission issued by the California Secretary of State that you will receive once you pass your state exam. This is true whether an appointment is for the first time or whether the person has been issued a previous commission. The critical starting date is the commencement date stated in the commission, rather than the date the commission was issued or mailed by the California Secretary of State on the date the commission was received by the person in the mail. However, a person cannot serve as a notary public until both their oath of office and their bond have been filed with the county clerk, and both must be filed within 30 days of the commencement date of the 4-year term stated in the commission. A notary public commission issued by the California Secretary of State does not take effect until the oath of office and bond are filed on time with the county clerk. If the 30-day deadline is missed, the commission is invalid. Section 2, Geographic Jurisdiction. A notary public's jurisdiction is not limited to the county in which the notary public's oath and bond are filed. But a California notary public cannot perform notarial acts outside of the borders of California. Additionally, a notary public appointed to serve on a military or naval reservation is authorized to act only within the boundaries of the reservation for which he or she is appointed. For an example, Maria Mobile's principal place of business is in Truckee, California. Accordingly, Maria filed her oath and bond at the Nevada County Clerk's Office in Nevada County of California. Maria often travels to South Lake Tahoe in El Dorado County to perform notarial acts for residents there. Patrick Pressure asked Maria to come to his home in State Line, Nevada, to perform an acknowledgement on a document to be filed in El Dorado County. Maria must refuse to perform the acknowledgement in the state of Nevada. As an alternative, Maria may request that Patrick meet her in South Lake Tahoe, El Dorado County, California, or any other convenient location in California to perform the acknowledgement. Section 3, the bond. A notary public must obtain a bond from a California admitted surety insurer in the amount of $15,000. The bond must be filed with the county clerk of the county in which the notary public's principal place of business is located. The bond is to provide a limited fund to reimburse members of the public who are damaged by notarial misconduct. However, the notary public and the surety named on the notary public's official bond are liable in a civil action for all damages sustained from a notary public's misconduct or neglect. A best practice tip is there may be personal liability for the notary public to the surety for the amount paid on the bond as damages, and if the damages exceed the amount of the bond. Therefore, a notary public should consider purchasing errors and omissions insurance or some other type of liability insurance to cover damages that may occur in the course of performing their notarial duties. A negligent notary public may still be personally liable for damages, costs, and attorney's fees exceeding insurance policy limits, and for damages not covered by the insurance. Section 4, Public Employee, Notaries Public. The California Secretary of State may appoint an employee of a California state, city, or county public agency or public school district to serve as a notary public for and on behalf of the public entity. These notary public employees only may perform notarial acts for and on behalf of the public entity employer. These notary public employees are not authorized to perform notarial acts on their own time. These notary public employees must maintain personal control of their journal. The public entity employer may pay the costs of the notary public's bond and supplies, and any fees collected by the notary public employee must be remitted or turned over to the public entity employer. If the notary public is terminated or resigns, the termination or resignation is treated as a resignation of the notary public's commission as well. On termination or resignation from employment with the public entity, 1. The employee must immediately send the notice of resignation to the California Secretary of State. 2. All notarial records must be delivered to the county clerk within 30 days. And 3. The notary public seal must be defaced or destroyed. Section 4 continued. The California Secretary of State may appoint federal civil service employees to serve as notaries public for military and naval reservations within the state of California. A notary public appointed to serve on a military or naval reservation must be a U.S. citizen but does not have to be a California resident. These notary publics may perform notarial acts only on the reservation for which they were appointed, and they cannot collect fees for any service. These notary public federal civil service employees must maintain personal control of their journal. If the notary public stops being a federal civil service employee, the commanding officer of the military or naval reservation must notify the California Secretary of State of the termination, and the termination is treated as a resignation of the notary public's commission. Again, upon termination of resignation from employment with the military or naval reservation, all notarial records must be delivered to the county clerk within 30 days, and the notary public seal must be defaced or destroyed. A notary public with a new commission is permitted to take and subscribe the oath in front of another notary public as long as the oath is administered in the county where the oath and bond for the new commission will be filed. In such a case, the completed oath and bond must be sent by certified mail or any other means of physical delivery that provides a receipt to the county clerk for filing. Best practice tip: the oath of office should be taken and subscribed in person at the county clerk's office to avoid mail and processing delays that may prevent the oath and bond from being filed by the county clerk's office on time. The commission will not be valid if mail or other processing delays prevent the oath and bond from being filed by the county clerk's office within 30 days of the commencement date stated in the commission. When a notary public visits the county clerk's office in person, an authorized employee of the county clerk will administer the oath of office, observe the notary public sign the oath, and file both the oath and bond the same day. The notary public must present an identification document meeting the requirements of as proof of identity. Section 2, the address change. California law requires a notary public to notify the California Secretary of State of address changes to ensure that the California Secretary of State and members of the public are able to contact the notary public about notarial acts the notary public performed. Notaries public must notify the California Secretary of State by certified mail or any other means of physical delivery that provides a receipt within 30 days of changing their business or residence address. Willful failure to notify the California Secretary of State of a change of address is punishable as an infraction by a fine of up to $500. Residence address. A notary public may not use a private commercial mailbox or post office box as the residence for his or her residence or principal place of business, unless the notary public also provides the California Secretary of State with a physical address of their principal place of residence. The California Secretary of State must have record of a notary public's actual residence street address. Mailing address, different from the business and residence address, is not required, but may be used if a notary public receives mail at a post office box or private commercial mailbox. Address change procedures. Any change to any of the three addresses inserted in the Notary Public application or to any previous address change notification must be reported to the California Secretary of State. For example, if a Notary Public indicated on the application for appointment that the Notary Public would perform services at the employer's location, and the Notary Public's employment ends for any reason, then the Notary Public must notify the California Secretary of State of another address and may state that they are now self or self-employed or provide the name and address of the new employer. If a Notary Public moves to a new home, then the Notary Public must notify California Secretary of State of the new residence address. If a Notary Public chooses to have correspondence sent to a post office box and the Notary Public cancels the post office box contract, then the Notary Public must notify the California Secretary of State of a new mailing address. The notification of California Secretary of State can be by letter or by the change of address form that can be found on the California Secretary of State website at this link. Best practice tips. In addition to the new address, the notification should include the name of the Notary Public, exactly as it appears on the commission, the commission number, and whether the address being changed is a business, residence, or mailing address. If the change is to a business address, the notification should state the name of the business that is located at the new address, if that is where the Notary Public will perform a majority of the notarial services, or that the Notary Public will be self-employed. There is no fee to submit address change form or address change letter. If the address of a Notary Public's principal place of business changes from one county to another, although not required, the Notary Public may take and file a new oath of office and bond, or may file a new oath of office and a copy of the original bond in the county where the new business address is located. If the Notary Public decides to make a new filing, within 30 days of filing, the Notary Public must obtain a new official seal that includes the name of the new county where the Notary Public has relocated. For best practice tips, when a new seal is obtained, the old seal should be defaced or destroyed since it no longer complies with the statutory requirements to the state, the county, where the oath and bond are filed. Section 4, Responding to Written Requests of the California Secretary of State. A Notary Public has two separate duties to respond to written requests of the California Secretary of State. A Notary Public must respond by certified mail or any other means of physical delivery that provides a receipt within 30 calendar days of receiving a written request for information from the California Secretary of State relating to official acts performed by the Notary Public. Within this time specified in the written request by the California Secretary of State, A notary public must furnish the California Secretary of State certified copies of his or her notary journal or any portion of the journal that is requested. Please note that the 30-day time period for requests for information does not apply to the requirements to provide certified copies of the notarial journal or portions of the journal. Respond as directed in the written request. Section 5. Agreements with private employers. A notary public employed by a private employer may be called upon to provide notarial services as part of his or her employment. The law permits a private employer and an employee who is a notary public to agree that the employer will pay the premiums on the notary public's official surety bond and the cost of any stamps or other supplies required in connection with the appointment as a notary public or for performing notarial duties for the employer. The agreement may provide the fees collected by the notary public for performing notarial acts as part of his or her employment are to be remitted or turned over to the employer for deposit in the fund from which the employee is paid. If the employer and the notary public employee have an agreement for the employer to pay bond premiums and costs for performance of notarial duties, the employer may limit the employee to provide notarial services solely to transactions directly associated with the business purpose of the employer during work hours. However, the notary public employee still can perform notarial acts outside of the ordinary course of employment on their own time. A notary public employee is responsible for following California law, regardless of their employer's demands. Performing an improper notarial act could result in civil or criminal liability for the employer and for the notary public employee. An employer who requests that a notary public perform acts that do not comply with California law should be referred to California Government Code Section 8225, which provides that any person who coerces or in any manner influences a notary public to perform an improper act is guilty of a misdemeanor. For example, Perry Paralegal is employed by a California lawyer, Adam Attorney, who is the sole practitioner and specializes in wills, trusts, and probate. Adam Attorney requested that Perry Paralegal obtain a notary public commission. So Adam Attorney paid for Perry Paralegal to attend a notary public education class and paid for Perry Paralegal's exam and bond. After a commission was issued, Perry Paralegal, Adam Attorney reimbursed Perry Paralegal for the costs of filing his oath and bond and the costs of buying his sealed journal and a supply of attachable jurat and acknowledgement certificates. Perry Paralegal signed a written agreement to perform notarial public services during regular office hours only at Adam Attorney's direction to collect fees for all services performed during regular office hours and to deliver all fees collected for services performed during regular office hours to Adam Attorney's accountant. Perry Paralegal's sister Sissy asked Perry Paralegal to come to her house after work to acknowledge an interspousal transfer deed she signed. Perry Paralegal may perform the acknowledgement after regular office hours, even though Adam Attorney has not directed Perry Paralegal to perform the acknowledgement. Perry Paralegal may also perform the acknowledgement and charge the statutory permitted fee for his services if he wishes, without delivering the fee to Adam Attorney accountant. This concludes Chapter 1, Parts B and C. Your next module will be Chapter 2, Part A and Section 1. Please do not forget to record your time for this module on your timesheet provided in your workbook. Let's move on to Chapter 2. Part A discusses tools to function as a notary public. including your notary journal.